I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. Kash Patel won't be able to hide his testimony in connection with the matters relating to Donald Trump stealing records from the government and hiding them at Mar-a-Lago because he's just been granted what's called derivative use immunity, which will require him to testify. He can no longer assert his Fifth Amendment rights against self-incrimination because the Department of Justice has confirmed that as it relates to the specific questions he is going to be asked and derivative uses from those questions of things they learn from those questions, they can't prosecute him, so they will be able to ask him questions. I'll explain what derivative use immunity is. I'll compare it to what transactional immunity is. But the key headline that's coming out of this is that Kash Patel, who pled the Fifth Amendment when he went before this criminal grand jury that is investigating Donald Trump's criminal conduct in violation of the Espionage Act and obstruction and concealment and mutilation of government records, which Trump stole by the thousands, including top secret, sensitive, compartmented information. Well, Kash Patel, when he went to testify on October 13th and pled the Fifth Amendment and refused to testify, he's now going to be compelled to testify. He's going to have to answer questions. Now, Kash Patel is very much involved in this. Why is he involved in this? Well, Trump appointed him to become a top Department of Defense official, namely to interfere with the peaceful transition of power, and he was the chief of staff to the Secretary of Defense. But then after that, he remained a top Trump ally who's been spreading conspiracies about the 2020 election and is a election denier and has been fanning the flames there in the MAGA extremist echo chamber. Well, he was also appointed by Donald Trump to be the designated representative with NARA, the National Archives. And Kash Patel's given interviews with right-wing extremist outlets like he did early May with Breitbart, where he claimed that he saw Donald Trump declassify all of these records, which he said was for our national interest, including what Kash Patel said were documents relating to foreign issues with Russia and other significant documents of national security interest. He said he wouldn't say more, but that he was there when Trump specifically sought out these documents to declassify these records. And so Kash Patel has demonstrated in that article that Trump stole these records and had specific intent on which records he wanted to take and steal, and that this was not some mistake or just some issue about cataloging records, which of course we don't know to be which we all know is not the case. But in any event, Kash Patel has been very much involved in all of the issues relating to Donald Trump stealing these documents and relating to his claims that he's aware of Donald Trump's intent relating to these records. But when Kash Patel was subpoenaed before the criminal grand jury that is investigating these crimes that Donald Trump committed for stealing government records, what did Kash Patel do? The same thing these MAGA extremists do all the time. I plead the fifth. I plead the fifth. I plead the fifth, and refusing to answer those questions. And so in that situation, the government could be faced with a few options here. They could just prosecute Kash Patel based on the information that they have. They could just allow him to plead the fifth and invoke his Fifth Amendment rights against self-incrimination. But you can't invoke your Fifth Amendment rights against self-incrimination if you are given two forms of immunity, two different types of immunity. One is called derivative use immunity. The other is called transactional immunity. And generally, the Department of Justice and Government prefers to give derivative use immunity. And derivative use immunity basically just states that the individual answering the question will receive immunity from criminal prosecution based on their answers to the specific questions they are being asked, as well as, and this is why it's called derivative use immunity, sometimes it's just referred to as use immunity, anything that is derived from those answers as well, the Department of Justice can't use to prosecute a person who's given derivative use immunity, in this case, Kash Patel, who's given derivative use immunity. Now, the reason that he can't plead the fifth if given derivative use immunity is because there is no fear of self-incrimination where there is this immunity. Now, derivative use immunity still would allow the Department of Justice to prosecute Kash Patel based on findings that they make independent of what he testifies to, as well as it has to be independent of the derivative uses of what he testifies to. So if they do want to prosecute Kash Patel, they still can. They would just have to prove that they got the information totally from independent sources other than Kash Patel's own testimony when he was given derivative use immunity. Also, if Kash Patel lies under oath when he is given derivative use immunity, he can be tried for perjury as well, and he can be charged with the crime of perjury. So he can't lie and give testimony. Now, derivative use immunity, which is more surgical because it's just about what the person who's given that immunity testifies to, and derivative uses, it's more narrow than what is called transactional immunity. And transactional immunity would give a person, in this case Kash Patel, but he's not been given transactional immunity, immunity from the overall crime of what the questions relate to. And so no matter what independent sources the Department of Justice may get information from, if Kash Patel was given transactional immunity, you can't charge him for that crime at all, no matter what. You could charge him with perjury if he lies, but you're saying that we're giving you immunity from the overall charge. But that's not what has happened here. Kash Patel has been given a very specific derivative use immunity, which is found under 18 U.S.C. 6002. And let me just read for you what the use immunity statute allows. It allows the government to prosecute the witness using evidence obtained independently of the witness's immunized testimony. Section 6002 provides, quote, no testimony or other information compelled under the order, or any information directly or indirectly derived from such testimony or other information may be used against the witness in any criminal case, except a prosecution for perjury, giving a false statement, or otherwise failing to comply with the order. But you can prosecute based on independent sources. So Kash Patel has been given derivative use immunity, not transactional immunity, and therefore he can no longer plead the Fifth Amendment because there is no longer any fear that he could engage in self-incrimination through his testimony because he's been given this derivative use immunity. Now, to get this derivative use immunity, the Department of Justice had to go to the federal judge. In this case, it's Judge Beryl Howell, the chief judge of the D.C. District Court, the federal courthouse in Washington, D.C. First, what the Department of Justice tried to do is just compel the testimony of Kash Patel anyway and say, look, there really is no fear of self-incrimination here at all based on the types of questions we want to ask him, so he shouldn't be allowed to assert the Fifth Amendment. Then the Department of Justice says, well, in the alternative, Judge, if you find that he could potentially self-incriminate himself, then we would like an order from you, the judge, allowing us to utilize this derivative use immunity and order and compel Kash Patel to have to testify on these topics with the derivative use immunity granted. That's what happened here. The judge basically had to make a finding. And look, all this is being done in a secret grand jury proceeding, so we don't have a copy yet of this order, and we may not have a copy of the order since all criminal grand juries by the Department of Justice all take place in secrecy. That's just the nature of criminal grand juries. juries pre-indictment, although the media has requested some other documents regarding these grand jury proceedings. But we know about it through sources who are familiar. We know that Kash Patel showed up on October 13th and pled the Fifth Amendment. We know that the Department of Justice sought to compel the testimony. We know that Kash Patel is going to have to testify. So piecing that all together, we've been able to determine conclusively and through sources that Kash Patel was given this derivative use immunity, this limited surgical immunity regarding these questions regarding Mar-a-Lago, Donald Trump's theft of these records, so that Kash Patel can no longer plead the Fifth and avoid testifying. Again, not transactional immunity, derivative use immunity. So for those wondering, why would they give Kash Patel immunity? Doesn't that just give a bad actor, kind of this freedom to do whatever? Well, no, because as I said, if Kash Patel lies, he can be charged with perjury. And further, the Department of Justice, like I mentioned with that Breitbart article, they already have independent sources of Kash Patel kind of admitting to crimes. So in any event, I feel like they still would have the ability to charge Kash Patel if they wanted to, based on all of the other independent knowledge that they have about Kash Patel. But what this also shows is how aggressively the Department of Justice is moving here against Donald Trump. This is a very aggressive move. It's all happening very, very, very quickly. And I think the Department of Justice is laser focused on that Breitbart article I talked about from early May, where Kash Patel talked about being in a room where Trump said he was declassifying all of these records, which essentially admits that Trump knew he was stealing these records, because that's the last piece of this case. I mean, any legal observer thinks this is already a slam dunk case against Donald Trump for Espionage Act violations, obstruction, and concealment and mutilation of these government records, including these top secret, sensitive, compartmented information. But the thing that the Department of Justice just wants to totally nail down is the intent element for Donald Trump. I've told you, I think they're going to prosecute. I'm confident they're going to prosecute Trump on the stolen document issues, including some of our nation's top secret records, like our nuclear records or nuclear information that he stole, and information relating to Iran's missile defense system, and information relating to Chinese military or China's military systems. This is some of the documents that we believe Donald Trump has stolen based on sources familiar with the investigation. But they're moving very aggressively right here against Donald Trump. They just brought in someone by the name of David Raskin, who was a top terrorism prosecutor, a top national security prosecutor. You only bring in Raskin in a situation like this if you're looking to prosecute. And then you see this move right here of giving this derivative use immunity to Patel to get him to answer these questions. And so Patel's not going to be able to plead the Fifth anymore. He's going to be compelled to have to answer all of these questions about his knowledge relating to the documents Donald Trump stole and kept at Mar-a-Lago. If Patel lies, he can be charged with perjury, and they can use the information from Patel to then prosecute Donald Trump. Now you've learned about derivative use immunity. You've learned about transactional immunity, the differences between them, why derivative use immunity was chosen here by the Department of Justice, and why they gave Patel. You've learned that Patel's not out of the hot water by giving him this derivative use immunity. He can still be charged for perjury. He can still be charged for crimes relating to the theft of documents at Mar-a-Lago, provided the Department of Justice can show that their information that led to the prosecution is not relating to or directly related to what he testifies to before the grand jury, or is not derived from it. If it comes from an independent source, the Department of Justice can still prosecute Kash Patel, and Kash Patel can no longer take the Fifth Amendment and invoke his Fifth Amendment rights against self-incrimination, because there is no longer the fear of self-incrimination based on his testimony if he's given derivative use immunity. A lot of complicated concepts, but you now understand them. You understand the strategy the Department of Justice is using here. But what it all boils down to, Department of Justice is compelling Kash Patel to testify. Kash Patel is going to have to testify. That testimony is going to happen soon. My prediction in the next week or so, but certainly in a very short period of time. And the Department of Justice is moving expeditiously in their prosecution, potentially, but certainly in their criminal investigation of Donald Trump for stealing, concealing, and obstructing with these records, thousands of government records, including these top secret, sensitive, compartmented records, some of our nation's highest of secrets. I'm Ben Meiselas from the MeidasTouch Network. Hit the subscribe button right now. We are on our way to 1 million subscribers thanks to you. Hit subscribe. Also, if you want to support independent media like this, you can check us out at patreon.com/MeidasTouch. patreon.com/MeidasTouch. There's lots of different memberships there. Join one if you can. We're not funded by any outside investors at all. So if you can join one of those memberships, it goes a long way to support what we're building here. And it would just go a long way. So we so much appreciate it. That's patreon.com/MeidasTouch. Until next time, I'm Ben Meiselas.
MeidasTouch is unapologetically pro-democracy. And look, we know you are too. So please make sure you check out our best-selling shirt and our best-selling gear, the unapologetically pro-democracy gear. And hey, while you're at it, make sure you check out my favorite shirt and one of our most famous designs. It wasn't rigged, you're just a loser. At store.MeidasTouch.com. That's store.MeidasTouch.com.